The Fair Labor Standards Act was first passed by Congress back in 1938 and set forth the national minimum wage and overtime requirements for businesses throughout the country. There are certain requirements that a business must meet before it falls under the provisions of the Fair Labor Standards Act. Moreover, the Fair Labor Standards Act also sets forth requirements for businesses as it relates to retaliation and termination against employees who file lawsuits under the Fair Labor Standards Act against their employer. If you or your business are sued in federal court under the Fair Labor Standards Act, the first thing you need to do is find and retain experienced counsel. There are certain defenses you may be able to raise in order to have your case under the Fair Labor Standards Act dismissed, but these arguments and these defenses need to be raised at the very beginning of the case. Otherwise, you could find yourself spending tens of thousands, if not hundreds of thousands of dollars litigating in federal court. In order to make it through a Fair Labor Standards Act case and keep your business intact, a company needs to have an aggressive trial strategy. This includes having a strategy to make it through discovery in the case. It also includes knowing when, where, and why to settle the case if the opportunity so presents itself. Finally, it includes being able to go to trial and prevail at trial, notwithstanding any of the roadblocks that you may encounter along the way. This law firm is dedicated to assisting business owners in litigation arising under the Fair Labor Standards Act. I'm also available to discuss any other litigation-related matters for business owners or any other employment-related matters that they may have.